Hi, Bill Henshaw here again, Constitutional Kook Headquarters, and this is part two of my video on the Federal Circuit Courts. And this looks like a dynamite. I mean, this is a ball buster here because if we get into a judicial court, that's where they have to recognize our status as state citizens and that we have creator endowed inalienable rights. And we are not persons, quote unquote, born in the United States and subject to the jurisdiction thereof. 14th War Amendment. Think about it. How in the world can we be subject to a jurisdiction that we ordained and established in the Constitution? I'd love to hear it. I really would, especially from you, John Roberts. I'd love to see you explain this one. But, the big deal for the purposes of this video, is to explain that we also have judicial courts in states. In California, the original Constitution here is great because it says it right in there, the California District Court. Constitutional common law court recognized contemporaneously as such. And that's where it is we need to be. But the point about the Judiciary Act of 1911, this was a precursor to the Judges Act of 1925. And it's embarrassing to say the four horsemen that were all on the court then were part and party to this. But they effectively did away with the common law writ of error and made some other changes in there in order to lessen the workload of the court. The biggest problem there was they were taking too damn many cases from artificial corporate entities who have no business in the judicial court. I've been mugged, Chase Bank, you name it, Ford Motor Company, Henry Ford, Inc. Those are our courts, not theirs. They want to create a Supreme Court for corporations, they're free to do it. Not relevant for us. So what they did was to do that, but I'm sure behind the scenes, and you probably won't read it anywhere, but they felt they could do it because of what they did in the Judiciary Act of 1911. And now we have not only writs of error available there, but a circuit court that's a judicial court. So there is one there, because otherwise the Judiciary Act of 1925 would have repealed a lot of terms and conditions of the Constitution, particularly Article 1, Section 9 and 10, about bills of attainder. And maybe that's one reason why the 90 Parks, aka the U.S. Supreme Court, haven't made a serious ruling on that issue since Cummings v. Missouri in 1867. Now, go in there and start raising issues like that, and not this BS due process and equal protection. That's 14th Amendment crap, and the 14th Amendment, as you'll learn, not only doesn't exist, it never did. Send me an email, youwinnincourt@gmail.com, and I'll send you information on my modestly priced constitutional defense document packets that are now going to include everything we're talking about here. And this is their bosses saying it, which means if they don't do it, and they're in a position of honor, profit, and trust in the de facto government and sworn by oath to this Constitution and laws enacted in pursuance thereof, and you don't exercise jurisdiction that you do have, and at one and the same time, you actively aid and abet courts that don't have jurisdiction to exercise it. There's that pesky U.S. Supreme Court again, Chief Justice John Marshall, Cohen's v. Virginia. The one or the other is treason to the Constitution. That's the type of claims we need to start to be making. And I think we've just gotten a long way, especially in the last year or so with the events I've discussed on the Supreme Court. But with this Judiciary Act of 1911, it makes it clear that these courts exist. And by the way, they exist in territories, and you'll learn. And if we are in territories, and that's the key issue for me, the crown jewel of all my unopposed issues, no states. Even if we're in a territory, this dual jurisdiction has to exist. You're going to love all of this. Because if it doesn't mean just because you're in a territory doesn't mean that Congress is without limits. A major element of the case of, I can't think right now, for goodness sakes, Scott v. Sanford, otherwise known as that infamous Dred Scott case, which wasn't anything of the sort. But all I learned about that in high school, and all you probably learned, was that Roger Brooke Taney, the Chief Justice, ruled that the black man had no rights the white man is bound to respect. you read the context he was talking about. That's back in the day when we didn't have states. We had colonies. Before we had the Constitution and all that. And at that time, it may well have been true. It isn't relevant now, and they could have made much better arguments in that Scott v. Senator case. I'll talk about that on a separate video. But that said, if you've read the case, and I haven't read all 300 pages, and that was a long, especially for that era, long decision. There were some dissenting opinions too. But I understand what they were talking about and why. And it was the correct decision across the board. And yet they want the CIA language and the government wants you to think that's one of the most infamous cases they ever decided. It simply isn't true. And you'll learn why. Send me an email, uwinnincourt@gmail.com. I'll send out information to you on my constitutional defense document packets. And you can go out there and do what I do, start to get it right. And now in a judicial court. That's some of the most exciting news I've had in my 5th decade now. Just entered my 40th year on Valentine's Day. But by golly, all of this makes sense. And you're going to love the way it does. And it's now going to be respected by at least the judges that are, bound by oath. Because this is the Supreme Court. Their boss is saying it, not us, them. How are they going to go against that? I'd love to hear it. So just a lot of good news this week, and it's only Monday for crying out loud. But we'll see, how things shake out here. But I'm really excited, and I should know better than that after all the time I've been involved with this crap. But if we really do have judicial courts, the ball game is over. Simple as that. So send me an email, uwinnincourt@gmail.com. I'll get you out information on all of this and more. Meanwhile, subscribe to the videos, like them, tell your friends, get the word out. The sooner we all start acting together and get rid of this divide and conquer crap they've been doing for way too long, the sooner we get these bastards off our backs. Thank you.